I wasn't supposed to be in that courtroom. Let me be honest about that up front. I was there as a favor. My cousin works in the clerk's office at the Old Bailey, and she'd been following this case for weeks. She said it was the kind of trial that only happens once in a decade. The kind where everything you think you know about justice gets rearranged in front of your eyes. She wasn't wrong. The case had been running for 11 days by the time I sat down in the public gallery. 11 days of lawyers in wigs doing what lawyers do, talking around things, building walls out of words, making the simple complicated and the complicated feel impossible. But that morning, the 12th day, something was different. You could feel it the moment you walked through the doors. The air inside the court was the kind of heavy that comes before a storm, not the weather kind, the human kind. His name was Corporal Declan Marsh. He was a Royal Guard, Queen's Guard formally, and he'd served for 14 years without a single mark against his record. 14 years of standing still while the world moved around him. 14 years of tourists and cameras and people testing the limits of his patience. By every account, he was the kind of man who didn't break, didn't flinch, didn't bend. And yet here he was, sitting inside a criminal courtroom in central London, called as a witness in a case that had split the city. The case itself involved a security contractor named Jeffrey Aldis, mid-50s, expensive suit, the kind of confidence that comes from never having been told no. Aldis had been charged with fraud, blackmail, and the illegal misappropriation of funds from a heritage preservation trust connected loosely to royal estate management. The accusations were serious. The sum of money involved was eye-watering, but what made it truly dangerous wasn't the money. It was what Aldis allegedly knew, and who he allegedly knew it about. I'll tell you what I noticed when I first saw Declan Marsh. He didn't look like a man who was scared. He looked like a man who was prepared, which is a different thing entirely and much harder to read. He was tall, had the kind of posture you can't fake, and his hands were perfectly still on the railing in front of him. He wore a plain, dark suit. No medals, no uniform, but you knew. The way he held himself, you just knew he came from a different world than most of the people in that room. The defense barrister, a woman named Eleanor Crane, had been picking apart witness testimony all week. She was good, unsettlingly good. She had a way of asking questions that felt polite and warm, and then suddenly you'd realize she'd walked you into a corner and the door had closed behind you without a sound. When she turned to face Declan Marsh for the first time, I noticed she paused, just for a second, the smallest recalibration. She'd done her homework. She knew who she was dealing with. The early part of his testimony was procedural. Yes, he had been present at a specific function at Windsor in March of the previous year. Yes, he had observed certain individuals in conversation. Yes, he had been stationed at a particular corridor on the east side of the building. Each answer was clean, clipped, factual. He gave nothing extra. He didn't embellish or hesitate. It was like watching someone navigate a minefield with absolute certainty about where every mine was buried. Then Eleanor Crane changed direction. She began asking about a specific evening, a private dinner that had taken place 7 months before the function at Windsor. A dinner that, according to the defense, Declan Marsh had also attended in a professional capacity. She suggested that on that particular evening, Marsh had witnessed something that contradicted the prosecution's timeline. Something that would cast doubt on the key dates they were relying on. Marsh said he had no memory of that evening. Crane pressed, politely, methodically. Marsh said again, he had no memory of being posted to that location on that date. The judge, a man named Hargreaves, white-haired, the kind of face that had seen too much to be surprised by anything, leaned forward slightly. He asked Marsh to clarify. Marsh clarified he had not been posted to that dinner. His roster records would confirm it. And this is where things went sideways. Crane produced a document. She held it up with the quiet theater that good barristers use when they know they have something. It was a staffing schedule, or rather, a copy of one. And according to that document, Corporal Declan Marsh had indeed been assigned to security detail on the evening in question. There was a murmur in the gallery. I felt the shift in the room like a change in pressure. Marsh looked at the document. He looked at it for a long time, and then he said something that nobody was expecting. He said, "That document has been altered." The murmur got louder. Hargreaves called for quiet with the kind of practiced authority that makes the sound die instantly. Crane asked Marsh to explain what he meant. Marsh said he could not elaborate at that time, but that he was certain the document was not authentic. He said he would need to verify it against records he did not currently have access to. Crane smiled in a way that wasn't really a smile, and said that the document had been obtained through proper legal channels and certified as authentic by the relevant administrative office. And then Hargreaves did something that nobody in that gallery had seen coming. He dismissed Declan Marsh from the courtroom. Not from the case, not permanently, but he instructed Marsh to step down from the witness stand immediately and to wait outside the court until further notice. He said, and I'm paraphrasing because my memory isn't a transcript, that the witnesses' claim about document alteration, made without supporting evidence and seemingly without prior disclosure to either legal team, risked compromising the integrity of the proceedings. He said the court could not allow unsubstantiated allegations of that nature to be made from the witness stand without proper foundation. It was firm, it was measured, and it was, by most interpretations, completely reasonable. But the way Declan Marsh stood up from that witness box, that was the part I keep coming back to. He didn't argue. He didn't look frustrated or embarrassed. He just stood, adjusted the front of his jacket with both hands, gave a single nod toward the bench, and walked out. He walked like he knew something the rest of the room didn't. Court recessed for lunch about 40 minutes later. My cousin found me in the corridor outside, and we ate sandwiches on a bench by the window. She told me what she'd been hearing from the clerks, that the defense team had been building toward this moment for days, that the staffing document was their centerpiece, that Crane intended to use it to establish that Marsh had been present at the dinner, that his earlier testimony about another matter was therefore colored by proximity to the accused circle, and that the entire prosecution timeline could be questioned. She said, if it works, Aldous might walk. I asked her what she thought about what Marsh had said, about the document being altered. She shrugged. She said witnesses say all kinds of things when they're cornered. I wasn't so sure. There was something about the way he'd said it, not defensive, not panicked, almost quiet. Like a man who'd just made a decision he'd already thought through very carefully. Court resumed at 2 o'clock. Marsh wasn't in the room. His seat in the witness waiting area was empty. The afternoon session was taken up with 2 other witnesses, a financial analyst and a former employee of the trust who spoke in a voice so low the stenographer kept asking her to repeat herself. It was important testimony, probably, but I couldn't concentrate on it. I kept looking at the door. At 3:20, a clerk came in and passed a folded note to the prosecution's lead barrister, a large, slow-moving man named Alastair Webb who had the look of someone who'd been doing this long enough to have run out of surprises. He read the note. His expression didn't change. He passed it to his junior. His junior's expression changed. Webb rose and asked to address the court. Hargreaves allowed it. What Webb said next pulled every head in that gallery forward by about 6 inches. He said that Corporal Declan Marsh, during the lunch recess and the subsequent afternoon hours, had located and retrieved the original staffing roster from a records archive held at a facility in West London. He had done this, Webb explained carefully, on his own initiative, using his existing security clearance, during the period when the court had asked him to wait. He had then made contact with the prosecution office and provided the original document, physical, unaltered, with chain of custody intact, which directly contradicted the version submitted by the defense. The original showed clearly that Marsh had not been assigned to the dinner, that his name had not appeared on the roster at all, that the version Crane had presented to the court contained an insertion, a name, typed in a font that on close inspection did not match the surrounding text, formatted differently, sitting slightly too high in its cell. It had been doctored. The room didn't murmur this time. It went completely still. I want to be careful here because I'm not a lawyer and I didn't understand every procedural step that followed. What I can tell you is what it looked like from up in the gallery. It looked like the floor opening under someone. Eleanor Crane stood very still for a moment. She spoke to her client in a voice too low to carry. Aldous, Geoffrey Aldous, the man in the expensive suit who'd been sitting at that table for 12 days with the patience of someone who believed the system could be managed. Aldous put both hands flat on the table and stared at them. Hargreaves called a brief recess. When he came back, his face was the same as always, completely neutral. But there was something in the pace of his movements, a kind of deliberateness. The way someone moves when they're making sure every action is correct because what happens next matters. He asked the defense to respond to the prosecution's submission regarding the documents. Crane stood and said her team would need time to investigate the provenance of the copy they had received and the chain of custody surrounding it. Hargreaves said she would have it. Then he said something else. He said that the court noted the conduct of the witness Corporal Declan Marsh, who during his enforced absence from proceedings had taken independent action that materially affected the case, and that this action would need to be formally reviewed in terms of its implications for both the trial and the manner in which it was carried out. In plain English, what Marsh had done was extraordinary. Whether it was inside the rules was a separate question. Declan Marsh came back into the courtroom at just after 4 in the afternoon. He walked back in the same way he'd walked out, quiet, measured, jacket straight. He was asked to return to the witness stand. Webb asked him one simple question. Why had he retrieved the original document during a recess rather than waiting for the court to formally request it through proper channels? Marsh was quiet for a moment, not the silence of someone choosing their words carefully to protect themselves, more like someone deciding how honest to be. He said, because he had spent 14 years in service, understanding that there are moments where waiting for the proper process means the truth arrives after the damage is done. He said he understood that what he'd done was irregular. He said he was prepared to accept whatever consequence that brought him. But he said he was not prepared to watch a fabricated document stand unchallenged in a courtroom when he knew, with certainty, that the truth was sitting in a filing cabinet 40 minutes away. Nobody said anything for a moment. Then Webb said, "No further questions." I left before the session fully closed. My cousin texted me later with the updates. The fraud charges against Aldous remained. The investigation into the document was handed to a separate body. Crane's firm issued a statement saying they had received the document in good faith. Whether that was true or not wasn't for me to say. What I could tell you was what I saw. I saw a man who had been told to leave, who had been dismissed, politely, legally, in front of a gallery of people, and who had walked out of that courtroom without argument or protest. And I saw what he did with the time they gave him. He didn't sit in a corridor and wait to be called back in. He didn't feel sorry for himself. He didn't go home. He went and found the thing that needed to be found. I read later that Corporal Declan Marsh received a formal rebuke for acting outside designated protocols during a live trial. It was logged. It was official. A mark on a record that had, for 14 years, been clean. He accepted it without comment, apparently. I thought about that for a long time afterward. About what it takes to do what he did. Not the dramatic part, not the walking back in with the document, but the quiet part. The part where he sat in that witness room during lunch knowing what he knew, deciding whether to stay in his lane or step out of it. Because the safe thing would have been to wait. The safe thing would have been to let the barristers and the judge and the system sort it out. It probably would have gotten sorted. Eventually. Probably. But Declan Marsh had spent 14 years learning the difference between probably and certainly. And when it mattered, he chose certainly. Some people follow the rules because they believe in the rules. Some people follow the rules because they're afraid of what happens if they don't. And some rare people, the ones you only really see clearly when the pressure is high enough, follow the rules right up until the moment the rules would let the wrong thing happen. And then they make a different choice. And they accept whatever comes with it. That's not rebellion. That's not heroism in the shiny, cinematic sense. That's just a person who knows what they stand for. And in that courtroom on that Tuesday afternoon, with the light coming gray through the high windows and the whole room holding its breath, that was more than enough.